right. Thank you for being here.
First of all, I would like to start off by saying I apologize to anyone that was affected by this tragedy. The officers, Hernandez and Dura, I believe it is. This is hard. My dad, the best father you ever lost. My baby boy. I'm sorry.
That's okay. Take your time.
Harry, I don't love you no less. My baby too. And I just want to say,
You got it, ma'am. Ms. Rosco, I know this is very hard, but we have a court reporter to take.
I said, Aaron, I love you no less. You're still my baby too. And I just want to say I apologize to everybody. And please take in consideration, that was not my son that day. I don't know who that person was, but it was not my son. I've never.
On August 8, 2025, in Cuyahoga County, Ohio, 24-year-old Aaron Sharp walked through his family's home in East Cleveland and, in the span of minutes, ended his brother's life, his grandfather's life, and very nearly the lives of two police officers who had no idea what they were about to walk into. Months later, in case number 74-96, judge would have to decide exactly how much of Aaron Sharp's life would be spent behind bars for it. But here's the question that hangs over this entire hearing. The one you won't get answered until the very end. How do you sentence a man whose own mother stands up in open court, looks at him, and tells the judge that the person who pulled the trigger that day wasn't actually her son? Now let's drop the bomb, because this case is not what it first appears to be. The state of Ohio had enough on Aaron Sharp to pursue the death penalty. They chose not to. Why does that matter?
I'm going to say a few things on behalf of Aaron, and I
Sharp, you can sit down. Relax.
I know that Aaron wishes to address it as well. He and I have spent some time, he and I and Mr. Reagan have spent some time talking about what he might say on this day. This is a day that he's been envisioning, not looking forward to necessarily, but understanding that this day would come for a very long time. August 8th of 2025 is the worst day in a lot of people's lives. A lot of those people are here in court today. And before I get to Aaron and turn my attention to him, I want to commend certainly the family that's here. Thank Ms. Rosco for the grace that she's shown here today in court. How can you imagine being in her position? One son murdered, the other accountable for that murder, her father killed. Probably the worst day of her life. The individuals, the law enforcement officers, not just the East Cleveland officers who are gathered here today, but the others that risked their lives in the response. None of what I'm going to say is meant to minimize what they've been through as well. I'm going to commend the East Cleveland Police Department officers who are present and those that are not for their efforts that day. And I want to thank the Cuyahoga County Prosecutor's Office for taking a measured view of this case. When you first encounter a case like this with these sort of facts, Judge, I think it's very easy to forget about the nuance, forget about what was going on in the lives of the people involved, including Aaron. This is a case that would have otherwise qualified for the death penalty had they chosen to go that route. They chose not to do that, and I think that's in part a recognition of who Aaron is and what he was going through in that moment. And again, none of the mitigation material that I'm going to offer to you today is meant in any way to minimize the loss of life, as well as the other harm caused, Judge. It is about as tragic of a case as I can imagine, because of the familial relationships involved, as well as, well.
Because once you understand the actual sequence of events, you realize this wasn't a moment of panic. Sharp killed his brother upstairs. He went downstairs and killed his grandfather. Then he left the house. He could have run. Nobody was chasing him yet. Instead, when Officer Joshua Dura responded to the call and had to step out from behind cover to approach the house, Sharp waited for him to be exposed and opened fire. Hours later, after a manhunt involving local, state, and federal agencies, officers found Sharp at a vacant motel. As they searched the property with flashlights, he shot Officer Hernandez too. 2 separate ambushes, hours apart, against 2 men who had never met him and never threatened him.
Sharp evaded arrest, and then there was a several-hour manhunt for him that involved virtually every law enforcement agency in this county, with state and federal agencies assisting. Several hours later, there was reports that he was seen at a vacant motel. Officers responded to that scene, and that's where Officer Hernandez was shot. With the court's permission, I'd like to just observe Officer Hernandez's following.
You may.
Reporting. Stop! Yeah! There's back out for it. Fuck me, it's not.
Judge, I see from Officer Hernandez's perspective, it's evident that nobody who was searching the back of that hotel saw Mr. Sharp. I mean, they're still just searching with lights when the gunshots rang out. Now, some of those gunshots you heard were one officer returning fire, but the first series were all shots fired by Mr. Sharp directed at the police officers. Both of those shootings could have been avoided. There was no confrontation between police officer and Mr. Sharp. And I don't mean to focus solely on the police officers. What happened to Mr. Charles Rosco and Eric Sharp, too, was just as tragic. You know, they were unarmed in their own home, surrounded, well, by someone they considered family when they lost them. I think it's important for the court to look at how these crimes transpired. Eric Sharp was isolated from his grandfather's shooting. He was upstairs at a different time. Then things went downstairs. I'm sure Aaron Sharp could have just left. No one was going to tackle him. But he then took his grandfather's life. Officer Dura.
This is where the case stops being abstract and becomes something you feel in your chest. The prosecutor played Officer Dura's body camera footage in open court, and the judge and everyone in that room heard, in real time, shots fired. I'm hit. I'm hit. That's not a script. That's a man getting shot while doing his job, captured live.
Shots fired, I'm hit. I'm hit.
The prosecutor also asked to show the court a photograph of Officer Hernandez's injury, and the room went quiet enough that you could hear people reacting before a word was spoken. A presentence investigation report, which is simply the document a probation department compiles on a defendant's background, mental health, and risk level before sentencing, had already told the judge something that should stop you cold-y. Despite 2 homicides and 2 attempted murders of police officers, Aaron Sharp was scored as only a moderate risk of reoffending. Sit with that. The system's own paperwork, the formal risk assessment built to protect the public, looked at a double murderer who ambushed 2 cops and essentially said, he's not that dangerous. That's the kind of irony this audience lives for, and it's worth screenshotting, because it tells you something about how these assessments work that the headlines never will. Then came the moment that gives this video its name. Marissa Rosco stood before the court as the mother of one victim, the daughter of the other, and the mother of the defendant, all at once. Through tears, she said, "Aaron, I love you no less. That was not my son that day. I don't know who that person was, but it was not my son. That single sentence became the emotional spine of the entire defense.
It is about as tragic of a case as I can imagine, because of the familial relationships involved, as well as what we just saw here on the body camera footage. But what I can tell you with some level of certainty, Judge, is that Aaron did not wake up that morning and think, I'm going to harm someone, or I'm going to end last today. I don't think that sort of thought process took place even as it was happening. I'm not here to tell you that he is not liable, criminally liable for his conduct. He is. He was evaluated, as you know, Judge, by more than one mental health professional. Those people, I think, have a view that certainly mental illness was at play. And I'm going to tell you, Judge, I believe that untreated, undiagnosed mental illness was a large part of what took place that day. He was diagnosed possibly with unspecified schizophrenic spectrum disorder by our court psychiatric clinic. And I can just tell you candidly, and I believe Mr. Reagan would wholeheartedly agree with this, Aaron is a different person today than he was the day that we met him. The day that you saw him on being arraigned, acting in a way that I have never seen him act. And I think his mother said it more perfectly than I ever could, is that was not my son that day, is what she told you earlier, Jeff. And I believe that she believes that because that is the truth. I don't think he was in his right mind when he did what he did. He is today receiving medical care and medication to include antipsychotic medication that has allowed his true self to emerge and rise to the surface. So that when Mr. Reagan and I talked to him, we've encountered a soft-spoken, humble, mild-mannered individual. Somebody who, if you didn't know.
Defense attorney Max Martin built his mitigation argument directly around it, telling the judge that Aaron had since been diagnosed, possibly with an unspecified schizophrenia spectrum disorder, by the court's own psychiatric clinic, and that antipsychotic medication had revealed a soft-spoken, mild-mannered young man who bore no resemblance to the person on that body camera footage. Aaron himself stood and said, "I wasn't in my right mind. I blacked out. I wish I could have got the help I needed sooner."
I'd like to deeply apologize to my family and the police officers that got hurt the day that event. I wasn't in my right mind. I was battling mental health crisis and I blacked out. Even though I wasn't in my right mind, I still hold myself accountable for what happened. And I wish I could have got the help I needed sooner. I hope everyone can forgive me.
So now the legal framework, because this is where most coverage of cases like this stops short, and it's exactly where the real story lies. Under Ohio law, judges sentencing a felony must follow the purposes laid out in Revised Code 2929.1 protect the public, punish the offender, and do both using the minimum sanction necessary, while not imposing an unnecessary burden on government resources. That's the law trying to balance punishment with practicality. But Ohio also has mandatory firearm specifications, additional prison time tacked on automatically when a gun is used, and those sentences must be served first, before the underlying charge even starts. Here, that meant a 3-year gun specification on each murder count and a 7-year specification on each attempted murder count, all 4 required to run consecutively to each other. That's 20 years of mandatory firearm time alone, before Aaron Sharp serves a single day of the underlying sentences.
With the principles and purposes of felony sentencing. Therefore, on count 2 for murder in violation of Revised Code 2903.02a, the court sentences you, first of all, to the 3-year firearm specification contained in Revised Code 2941.145a. That 3-year firearm specification must be served prior to and consecutive with a sentence of life in prison with the possibility of parole after 15 years. That's the statutory mandatory sentence. On count 7, again, the court sentences you to the 3-year firearm specification in violation of Revised Code 2941.145a. That must be served prior to and consecutive with any other firearm specification contained in any other count. And then the court sentences you on count 7 for the murder count to life in prison with the possibility of parole after 15 years. On count 11, this is the attempted aggravated murder of Patrolman Joshua Dura in violation of Revised Code 2923.02 and 2903.01E1. You are sentenced to the 7-year firearm specification contained in that count in violation of Revised Code 2941.1412A. That 7-year firearm specification must be served prior to and consecutive with any other firearm specification contained in any other count, as well as consecutive with an indefinite sentence in count 11 of 10 to 15 years. So that's the minimum period, as I explained to you, pursuant to Reagan Tokes would be 10 years. The maximum pursuant to Reagan Tokes would be 15 years. In count 14, attempted aggravated murder count involving Patrolman Hernandez in violation of Revised Code 2923.02 and 2903.01E1, again, felony of the first degree. You are sentenced to the 7-year firearm specification in that count in violation of Revised Code 2941.1412A. That 7-year firearm specification, like the other firearm specifications, must be served consecutive with any other firearm specification in any other period of incarceration that you receive as a result of this sentence. You'll also be sentenced to a term on count 14 for the attempted aggravated murder of 10 years. The court imposes counts 2, 7, 11, and 14 consecutively. The court.
On top of that, Count 11 fell under Ohio's Reagan Tokes Law, which gives certain first-degree felonies an indefinite sentence, a minimum term the offender presumptively serves, with the state prison system holding the power, not the judge, not a parole board's normal process, to extend that incarceration if the inmate is deemed a continuing threat. Now the resolution, and the number that puts this whole hearing in perspective. The judge ran every count consecutively, finding that consecutive sentences were necessary to protect the public, and that the harm caused was so great that no single sentence could reflect what happened. Stack it up 20 years of firearm specifications, then life with parole eligibility after 15 years on each murder count, then an indefinite 10 to 15-year term, then a flat 10 years. By the court's own math, Aaron Sharp cannot even ask a parole board to consider releasing him until he has served roughly 70 years. He is 24 years old. This is not a man getting a second chance in his lifetime. This is a sentence that outlives the sentence itself.
The court imposes counts 2, 7, 11, and 14 consecutively. The court finds that consecutive service is necessary to protect the public from future crime and to punish the defendant. Consecutive sentences are not disproportionate to the seriousness of defendant's conduct and to the danger defendant poses to the public, and that at least 2 of the multiple offenses were committed in this case as part of 1 or more courses of conduct, and the harm caused by said multiple offenses was so great or unusual that no single prison term for any of the offenses committed as part of any of the courses of conduct adequately reflects the seriousness of defendant's conduct. Sir, the court notes, as Mr. Martin eloquently stated, this is a tragic case, not only for your entire family, for the entire Sharp family, but for the entire East Cleveland community and for all police officers everywhere. I want to recognize and commend the heroic actions of the police officers who risked their lives to save fellow police officers and to ensure that no one else was injured. I agree with Mr. Martin and with Mr. Schnatter that this is
Undiagnosed mental illness and guns don't coincide. And when they do come together, we see things like this. I recognize it, Mr. Sharp, but it's not a legal excuse.
for your actions. I do recognize that it's rare that we see a 24-year-old in front of me on a case like this with no prior criminal history. But again, that's not a legal excuse. So,
Zoom out, and this case is bigger than one family in East Cleveland. It's about what happens in the gap between mental illness and the legal system, a gap this judge himself acknowledged when he said undiagnosed mental illness and access to firearms don't coincide. Well, and when they do, we see things like this. Recognizing that gap is not the same as excusing what happened in it. The judge was explicit this is not a legal excuse. But it is a warning, repeated in courtroom after courtroom across this country, about how often the system identifies the danger only after the damage is already done.
With Mr. Martin and with Mr. Schnatter, that this is undiagnosed mental illness and guns don't coincide. And when they do come together, we see things like this. I recognize it, Mr. Sharp, but it's not a legal excuse for your actions. I do recognize that it's rare that we see a 24-year-old in front of me on a case like this with no prior criminal history. But again, that's not a legal excuse. So,
here's what you should take away from this one. The next time you hear that someone snapped, ask whether the evidence actually supports panic or whether, like here, it shows someone who had every chance to stop and chose not to.
I know the court has a pretty detailed description of how things transpired inside the house. There were two separate incidents, one upstairs where Mr. Sharp took the life of his brother, and that went downstairs where he encountered his grandfather and then shot his grandfather. At that time, East Cleveland officers were working a traffic accident. They received a dispatch to respond to the house. And I do have a body cam video of Officer Dura's approach that I would like the court to see, because I think it's important to see how this shooting transpired.
you may. And it's connected to that table?
Yes, Your Honor.
All right, what are we watching?
So this is Officer Dura's body camera as he's responding to the call, and we can fast forward it to the point that they get to the scene. Judge, what immediately precedes that is Officer Dura takes an approach from the side using a house for cover. He enters where you see the shooting happen on the driveway, so he has to leave cover, exposing himself as he's trying to respond to the scene. It's important to note that this shooting happens after Mr. Sharp leaves the house. He could have easily have fled that area the same way he fled after he took that shot at Officer Dura. Instead, he waited for the police to arrive, waited for Officer Dura to expose himself, and then fired. You heard multiple rounds. Mr. Sharp.
Here's what you should take away from this one. The next time you hear that someone snapped, ask whether the evidence actually supports panic or whether, like here, it shows someone who had every chance to stop and chose not to.